Hi folks, it's Denise Howell here, and we're asking on This Week in Law this week what S&M and copyright have in common. Both can be painful. The Show Me State wants teachers to show students less, and congratulations, Britain. Soon you'll be able to burn a DVD just like the rest of us. Fred von Lohmann from Google is with us, social media lawyer Michelle Sherman, and Trevor Timm's got that new lawyer smell. Next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 123, recorded August 5th, 2011. I'm on a virtual horse. This episode of This Week in Law is brought to you by Netflix. Watch thousands of TV episodes and movies on your PC, Mac, iPad, iPhone, or TV instantly, all streamed directly to you, saving you time, money, and hassle. For your free 30-day trial, go to netflix.com/twit. And by squarespace.com, the fast and easy way to create a high-quality website or blog. For a free trial and 10% off your new account for 6 months, go to squarespace.com and use offer code TWiL8. Hello and welcome to This Week in Law. I'm Denise Howell, and we've got a fantastic panel of folks for you this week to talk about all things related to technology and the law. Joining us once again on the show is Fred von Lohmann, Senior Copyright Counsel at Google. Hello, Fred. Great to have you back on the show.
Hey, Denise.
Wonderful to see you there. There we go. Goodness, you're surrounded by racks and racks of media there in your office.
Actually, I'm at home today, so you're getting a peek at my CD collection.
Wonderful. It's great to see that you are well supplied in that regard. We've got some good stories about playing CDs and DVDs as well to talk about later. So hopefully you'll be able to help us out when we need to pull one down off the rack. Also joining us once again on the show is Trevor Timm from the Legal As She Is Spoke blog. Hello, Trevor.
Hi, how you doing? Thanks for having me back.
It's great to see you again. Thanks for joining us. And joining us for the first time is Michelle Sherman from the Social Media Law Update at Shepherd Mullen. Hi, Michelle. Great to have you.
Hi, it's great to be here.
So we've got a ton of stuff to talk about. I think I want to lead off with the Zadiva case, because the last time we had Trevor on the show back in April, we were just considering Zadiva and what its fate was going to be. Well, we now know what its fate was. It has been enjoined from operating. And I think that Zadiva is a really interesting kind of a service, and it's fascinating that the judge got to where he did in this case, the way that he did. So for those not familiar with it or who haven't been following along, Zadiva tried to create a business around having a tower, a whole system of towers of DVD players at its location. And its customers were literally renting space and time on those DVD players to play movies back to them. So it was not streaming per se. It was remotely watching somebody else's DVD player. However, cutting that finally didn't get anywhere with the court. The court decided that its business model was just as illegal as somebody illegally in an unauthorized, unlicensed way streaming movies directly online, and the whole DVD aspect and DVD tower aspect of it didn't make any difference. So Zadiva has been enjoined, and they're out of luck. So, Trevor, we were bandying about what would happen to these folks. Are you surprised at all?
No, I don't think so. I mean, last time we were talking, I think the basis of our discussion was an article actually by my former internet law professor, James Gerlman, where he talks about how this case is, I mean, Zadiva kind of had a clever way of getting around the law, saying that it's not necessarily a public performance per se, because you're renting the DVDs essentially and watching them in the privacy of your home. But there was another case kind of exactly similar to this, but kind of like an analog analogy, Columbia Picture Industries versus Red Horn, where people would go into a video store and have DVDs set up by the employees, and they would hit play, and then you get to watch it in the privacy of your own booth, essentially. And what James Groen was arguing is that, while Zadiva kind of got around the letter of the law, per se, that the courts probably weren't going to allow them to continue because they're essentially just streaming the video in a way that can sort of get around all of the previous kind of restrictions. So to say that it's a surprise, I think, is kind of a stretch, because they're essentially doing the same thing, just in a different way.
Fred, do you think it should have made any difference that these are playing from DVD players before they get sent out to the customer base?
Yeah, I think it certainly might have made a difference, and it still might. It's important to note that this was a preliminary injunction order, and there's a good chance, I'm guessing, that Zadiva is likely to appeal this. And so I don't think we necessarily have heard the last of this case. I disagree a bit with Professor Grimmelman on this issue. I actually think Zadiva has a pretty plausible argument under a case in 2008 involving Cablevision, the cable television provider in the New York area, that offered a remote DVR, basically a TiVo in the cloud for its subscribers. And there the court in New York, and this went all the way up to the Court of Appeals, which said, look, as long as you're only sending a stream over the internet to one person, then it's not a public performance and you don't need the copyright owner's permission to do it. And so that was basically the case on which Zadiva relied. Now, the district court in Los Angeles didn't accept that analogy. And really the key distinguishing factor, according to the court, was that in Zadiva's case, each DVD could be viewed by multiple different people, not at the same time, because as you point out, you had to rent the DVD player, and for the period of 4 hours when you did that, the only person who could remotely control and watch from that DVD player was you. But the court found that in the Cablevision case, the copies were unique. They were only used for one subscriber ever. And so the court really seemed to rely on this notion that Cablevision was about a unique copy for each user, never to be used for anyone else. And in Zadiva's case, it was one DVD that was being used for multiple people in seriatim. So I'm not sure why that should make a difference. I actually think in some ways the key issue is whether there is such a thing as a private performance in the world of the internet, because the Copyright Act does not control private performances. So we all agree that when a television station puts a show on the air, that's a public performance and you need permission from the copyright owner to do that or some other defense. But if that's a public performance and Congress meant not to control private performances, well, then what is a private performance? Obviously, when I play in my living room, it's a private performance. But why should the answer be different if I happen to have a DVD player connected by a really long wire over the internet that just plays in my living room? So I think there's actually quite a bit interesting in the case, and I think it'll be an interesting appeal if that's what happens.
Yeah, I think it'll be fascinating, too. And I like your bringing up the issue of what's public versus private in this day and age. We were talking before we started recording the show about Google+, which is, of course, changing our perceptions of being able to distribute something publicly or privately. And I could see how, you know, someone might develop a business model around that kind of sharing, and you'd get into issues of, you know, if I've shared this with a limited circle of friends, the same number of people I would have had physically come over to my house and sit down and watch on my big screen, but they happen to be in their own homes at the time. You know, are we going to cut things that finely? What do you think, Michelle?
You know, I haven't followed it quite as closely, but I am troubled by the fact that it is a business model, and the purpose of setting it up the way they did is to try to get around the rules. So I appreciate everything that Fred's saying, and I think it's an interesting issue to follow in the courts, but I would imagine at the end of the day, they're going to say that this is something that it was proper to have the preliminary injunction. They shouldn't be able to do this.
All right. Well, we weren't surprised at all to see this come down, but as Fred points out, the Ninth Circuit is probably the next destination for this case, and we'll anticipate some briefing there. There's been a lot going on in the United Kingdom this week. A very significant ruling about British Telecom, which was sued by the entertainment industry to shut down a particular file sharing site. And shut it down in a way that, the site will still operate, but the users of British Telecom are going to be blocked from actually accessing that site using their ISP. So it was a test case that the court acknowledged it was going to be the first trial run of these kinds of arguments, and then the MPAA and others on the plaintiff's side have indicated, yes, we're going to go to other ISPs and demand that they too block this site. So it's just another way of battling on the infringement front, and it seems like this one has gone to the entertainment side of things. Fred, do we anticipate this kind of argument coming across the pond soon, or is this going to be unique to Britain because of its particular legal structure?
I actually think this ruling, which involved the website called Newsbin, which actually is a Usenet site, is actually a very, very interesting one and very important because it's really the first time we've seen a very high-profile order to a major ISP to block a domain. So as you point out, this is not about taking down Newsbin's site from its hosting provider. In fact, apparently it's sort of hard to figure out where they're hosted, or they've basically moved outside the UK. So the issue really is, what can you do with an offshore site that a court finds is infringing? The court can't take that site down. Well, one alternative, and this is something that's being pressed not just in the UK, but also in Italy, and also in the United States in the pending Protect IP legislation. The idea is maybe we can get ISPs to block the domain so that users can no longer access that site. So it's an important case, I think. It's very interesting. We'll see. The details are yet to be worked out. The details of what BT has to do are going to be decided sometime, I think, in October. But as a precedent, it's very interesting because, as you point out, it's a test case. So I think the British recording industry has already announced an intention to bring additional injunctions against other websites, again, to get ISPs to block the domains so that users can't access those sites. Some of your listeners and viewers will obviously realize this could set off a real arms race among proxy services and all kinds of other things to get around these blocks. But from a legal point of view, this is really a new front that rights holders are really pressing, not just in the UK, but across Europe and also in the United States.
So this is a bit different than what here in the U.S. some lawmakers are trying to accomplish through the Protect IP Act. Can you explain why that is?
Actually, I think it's very, very similar to what lawmakers are trying to press. So the Protect IP Act, which is currently pending in Congress, it was passed by the Senate Judiciary Committee a short while ago. And what it basically would do is it would allow rights holders and the Department of Justice to go to a court and get a court order against a site that would be deemed to be dedicated to infringing activity. And at least where the government went and got the court order, the government could then turn around and give that court order to an ISP, and the ISP would be required to do, in that case, DNS blocking. So it's not so much blocking the IP address, but just blocking the resolution of domain names so that when you typed in Newsbin or the Pirate Bay or a site like that, you basically wouldn't be able to access it because your ISP would not give you the appropriate IP address to match that domain name. So the concept is basically the same. The idea is we're going to get ISPs to block their users from being able to access these sites that are particularly offshore sites that are difficult to reach with any other legal process within the U.S. So that's why I think there's some other provisions in the Protect IP Act that also try to pull in people who host links, people who provide payment services, people who provide ad networks. But the piece here that's very similar to the UK ruling is this idea that we're going to get ISPs to block these sites so users can't get to them.
Trevor, when you look at this and you think about the prospect of going around to ISPs and trying to get them to block particular sites, do you think that this, first of all, do you think it's a good idea? And secondly, do you think it's logistically a pretty cumbersome route to try and go, or is it perhaps the only thing they can do?
Yeah, absolutely. I mean, there have been a few cases in the U.S. in the last 10 years where certain laws, like anti-child porn laws, said that the ISPs had to block these domain names or ISPs to stop people from using them. But courts have pretty much uniformly struck these laws down because they're overbroad, as in that they'll block services that have nothing to do with child porn, or that they're just cumbersome on the ISPs because they don't have the technology and it's going to cost them a lot of money. That's what I thought was interesting about this case, was that BT already has this existing clean feed technology, which could, assuming that the judge is correct, effectively block these websites. I'm wondering if the advancement in technology will make courts kind of reconsider that in the future in the U.S., saying that, well, now that it's not so cumbersome for these ISPs to block these sites, and maybe they can kind of target them more specifically, that they'll allow them to go through. Not to say that I'm in favor of them blocking any of the sites, but it would be interesting to see how the courts approach this now that the technology is kind of advanced. And I think there's actually also another comparison to another bill going through Congress right now, which is essentially a bill that is supposed to stop children from accessing pornography. And it's actually, I mean, it's been referred to as the data retention bill. And it's similar because this law that they used in the UK was actually originally supposed to be used only for blocking child porn. And now they're taking it by expansive in another direction and going after copyright claims. And the argument has been made in Congress and by a bunch of public interest groups saying that this Protect Children from Child Pornography Act isn't at all what the bill would accomplish in reality. It's that even Representative John Conyers, who's on the Judiciary Committee, said that the bill doesn't protect from children from internet pornography at all. It just essentially creates a database for everybody in the country to log what they see on the internet. Essentially what the bill does is allow or forces ISPs to keep a log of everybody's customer information for 18 months, whereas essentially it's saying that every internet user is guilty until proven innocent, and it forces ISPs to keep tabs essentially on their customers when there's essentially no evidence of wrongdoing. And this, again, could be used in copyright cases as well, even though...
Yeah, we've got a pretty concrete example of that right here, right? Where something that was established, both the filtering technology and perhaps the legal basis of the law, the policy basis of the law.
It's, nobody's going to be against a bill that says we're trying to protect children from pornography or child porn. So it's an easy way for law enforcement and legislatures to get through these expansive laws, and it ends up kind of taking in all this collateral damage and doesn't actually address the problem they're trying to solve.
I guess what I'm most concerned about with this kind of strategy is the due process element of it. For lack of a better word, it's not, technically due process here, but it is the notion that a site, going back to the Betamax case, the notion of substantial non-infringing uses, that a site that was used for multiple purposes, but yet also some copyright infringement was taking place there, could be blocked per one of these kinds of strategies. Michelle, do you have any take on that?
I was just going to mainly say the similar thing to you, what you were just saying, is that I think in this case, everyone pretty much agrees that the site is engaging in this piracy and that they are essentially, making available movies, videos, games, etc., that they don't have the license to be providing. But then I can see cases in which it's not quite as clear. And then you have courts basically turning to the ISPs and saying, okay, well, now this technology is available and there's been some kind of showing, so we're at least going to issue, for example, a preliminary injunction type of order. So I'm concerned about that aspect of it. But having said that, I think if you have a very clear case where there is this type of piracy going on, it's not a burden on the ISP because the technology is out there. Perhaps they're using it already, as in this case with the child pornography sites. I don't know that it's necessarily a bad thing, because what I think back to is I think back to the situation of Napster before Napster was charging its users, and you had all these people downloading information or music, etc., from Napster, and then years later or months later or whatever, being hit with litigation. And we saw that with college students. We saw that with a lot of individuals. So if this is a way to basically make sure that we don't have this information being taken and it will keep from having all those sort of splinter lawsuits happening from it, I don't know that's necessarily a bad thing. But again, I would emphasize that you really need to have the showing that the site that is being blocked is engaging in these type of unlawful activity, and that they don't have lawful purposes going on as well. So I would definitely want to make sure that the courts are requiring a high showing. And again, I should probably just throw out there that obviously all the views I expressed today are my own and not my firm's. Thanks.
Yes, absolutely. So I don't know. I mean, I look at this and I see just another strategy that's based on whacking moles rather than coming up with new and more sensible business models. My son just last night, he's 7, by the way, and sophisticated enough to know that if he wants to see a movie that's still in the theaters and not out on DVD, his suggestion to me regarding Cars 2 was, Mom, why can't we just watch this over the internet? And I, had to give him the explanation of why that can't happen, and tried to do so in as straightforward a way as I could. And his response to me, unprompted, was, well, gee, that's just stupid. I want to watch the movie. I'm happy to pay for it. Why shouldn't I be able to? Fred, what do you, let's put a cap on this discussion before we move on. What do you think about this particular strategy?
Yeah, I think you're onto something there. The bottom line is throughout history, the only successful tactic ultimately against piracy has always been better authorized legitimate alternatives. And so on this, I would just say it seems to me clear that the debut of Spotify, including a free tier for music listeners in the United States, I think the debut of Spotify is certain to make a much bigger dent on infringement online than any domain blocking site by site. And so, I think there's a huge place here for better legitimate alternatives. And I just want to echo what you said, Denise, which is, we have to be worried about what this will mean for due process, what this will mean for sites that are engaged in legitimate activity and have some infringing activity, right? I just want to remind folks that it wasn't so long ago that Viacom and many others in the entertainment industry declared that YouTube was nothing but piracy. And imagine if in 2005, when YouTube was just a little startup long before they were part of Google, in 2005, if they had been targeted for some sort of action in the UK or something like that to be blocked, it would have been exceedingly difficult for a small startup to fight all around the world to demonstrate that they, in fact, were not pirates. And so I think we have to be very, very concerned about how these things get implemented.
Yeah, absolutely. All right, we're going to have...
Just a quick...
Sorry, go ahead, Trevor.
Well, you were talking about the whack-a-mole strategy, and I actually thought there was an amusing part of the decision where that was part of BT's argument that essentially the block would be ineffective and users would easily be able to circumvent it. The judge said, so he said, even assuming that they all have the ability to acquire such expertise, it does not follow that they will all wish to expend the time and effort required. So the judge is essentially saying that that argument, he's assuming that all these users are lazy and won't be able to figure this out, and that's why this argument doesn't hold water. And I just found that kind of funny because as we've seen through Napster and all of its predecessors, that these types of technologies always adapt. The users adapt quicker than the record labels, and that just seems like an ineffective argument to just completely discount the whack-a-mole argument.
Yeah, even if many users wouldn't go through that process, they may have curious and frustrated 7-year-olds in their household who are more than willing to take the time and go through the steps. Well, before we get on to more copyright news from the UK, which has been having a lot of happenings along those lines in the last week, I do want to thank a very legal and very friction-free alternative to the movie-watching conundrum, Netflix, who is a sponsor of our show. We're brought to you by Netflix, which streams tens of thousands of TV episodes and movies directly to you instantly, which means you save time, money, and hassle. They've got all their licensing in order, and they've got an amazing library of stuff ready for you to enjoy. There are several easy ways to instantly access streaming movies and TV shows with Netflix. You can watch them on your Mac or PC or iPad. And the iPad app is just fantastic. You can watch on your iPhone and some Android phones too. If you have a gaming console, an Xbox 360, a PS3, a Nintendo Wii, you can watch it right there on your TV via that console. And if you're not a gamer, you can watch it with an Apple TV or a Roku. They're really inexpensive and easy to use. Lots of alternatives out there, including your DVD player may have the Netflix software built right in. With Netflix, you can watch movies and TV shows instantly using any of these devices, and you can begin watching a movie or show on one device and then finish it on a different one, which is just another way that they make things easy and convenient for you. Whichever way you choose to access Netflix, you can watch as many movies and TV shows as you want, anytime you want, and you can cancel at any time. So if you're not already a member, try it today for 30 days, absolutely free when you go to netflix.com/twit. Use that URL. And you can sign right up, and we hope you enjoy watching instantly with Netflix. Tell your friends if you're already a member, because this 30-day offer can apply to anyone. So thanks so much to Netflix for their support of This Week in Law. All right, so also in the UK, there was an interesting ruling that seems to suggest that linking to newspaper articles may be problematic. This reminds me of the early days of the internet when there was a lot of controversy about what you could link to legally. Fred, have you taken a look at this, and are you concerned?
This is another very interesting case coming out of the UK. The case is NLA versus Meltwater. And it's sort of an odd circumstance. It's basically a company whose business is providing press clippings to other businesses. You may think in the era of the internet, who pays for that anymore? But actually, lots of people do. And what the company that does the clipping service, they had a license from the collecting society in the UK that represents all the newspapers. So they were not actually violating the law. But the argument was, yes, you may have a license, but your customers don't. And so all of your customers are violating the law unless they also get a license from the collecting societies that represent the newspapers. So as you might imagine, the company said, well, wait a minute, our customers are really going to hate that answer. They have to pay us, and then they have to turn around and pay you again. And so they went to court to have a fight about this question, whether or not providing press clippings is copyright infringement, and whether or not it's the customers have to pay a second time, basically. And the court, in a decision that I think was a surprise to a lot of copyright people in the UK, basically said, yes, the user is making their own copy, and those copies may include headlines, which the court said some headlines are probably original enough to be copyrightable. They may also include excerpts. And in fact, the court went so far as basically to suggest just loading the web page of the news story itself might be copyright infringement when done by the end user. So all of this basically boiled down to the court saying, yeah, it's two different things. One company can put together clippings and send them to you, but for you to actually open it and click on anything, that might require a second license, at least assuming that the headlines were original enough and the excerpts were long enough and things like that. So it's a very interesting ruling. It raises this real disturbing possibility that simply reading a story or following a link that loads a story in your browser might be copyright infringement in the UK that would require either a license or some sort of a statutory exception. And in some ways, I think, and I think we'll talk about this in a minute, but I think this will add fuel to the fire in the UK that they really do need to make some changes to their copyright law to accommodate sort of common sense, everyday, I surf the internet, I read the news, I shouldn't be liable for copyright infringement when I follow a link. And there is a process going on in the UK right now to try to create some copyright reforms. But that's, there are a bunch of rulings here. The idea that headlines are copyrightable, the idea that short excerpts could infringe, and perhaps most troublingly, the idea that temporary copies made on end-user computers in the course of browsing the internet might infringe. All of those rulings were things that I think surprised some people.
Yeah, that's the thing that opened my eyes the most about this outcome, because it seems to me like we've long since resolved the issues of browser copies and not related, but still another instance of copying that shouldn't be infringement, what it is that search engines do in order to be able to serve up search results. Trevor, any thoughts about this?
Yeah, I mean, I'm just wondering how they would ever be able to enforce this ruling if it stands up, because if you were to play it out, it's essentially saying kind of what Fred was saying, that basically anybody in their work office who would read a paper that typically gives terms and conditions saying that you can only use this for personal and non-commercial use. And there's, hundreds and thousands of jobs where people are required to read news for their livelihood. And this would essentially be saying that if you're reading a newspaper at work, then you're in violation of this copyright law. And for them to enforce that over millions of people every day just seems kind of ludicrous to me.
Right. That was a really interesting point, too, that if something's licensed for non-commercial use only, that it suddenly becomes a commercial use because you're using one computer versus another. Michelle, did you have any insights on this one?
My only thoughts on this was that I thought it was really troubling for the reasons that everyone's mentioned. And especially it just doesn't make sense that the original news source would even want this type of ruling and this application of it, because they get a benefit from people clicking through and looking at it on their computers. So essentially what would happen is they're not going to appear as high up in the Google search, for example, if people feel like, gosh, I can't be clicking on this because I could be potentially violating this UK rule. So I just agree, I think, with Trevor, that I think an application, there's just no possible way that you could enforce this type of interpretation. And it's one of those, it's a perfect case that sort of demonstrates those slippery slopes that people are always are concerned about, and for a good reason.
So, Denise, before we leave this, I
Yes.
just want to mention on the enforcement issue, it's interesting. In Europe, there is much more tradition of having collecting societies that represent basically all the newspapers and then go around and charge every business a small fee every year. So I don't think the end game here is that newspapers are going to go out like Righthaven has done perhaps here in the United States and sue individuals. Rather, I think what this is an overture that would result in every business in the UK being required to pay a little more or a little something to a collecting society that then doles out the money to the newspapers. I think that's sort of where the enforcement theory is headed here. So in some ways, it really goes to this question of, who should be paying and how do we pay for journalism? I'm not sure the legislature in the UK had this outcome in mind, but it does show you one more way that copyright owners are thinking about how to cover their costs.
Yeah, I guess that's one way of dealing with the Craigslist problem. Have everybody have to pay even if they're not subscribed as a subscriber to the paper. As long as we're over there in the EU, Michelle, you had some interesting cases that you wanted to get to about, and again, we've been talking about indirect liability for user activities in the copyright context. That happens in the trademark context too, and we're looking at perhaps a conflict between what's going on in the EU and a very recent decision here in California about who can be held responsible for the sales of counterfeit goods on sites. Can you bring us up to speed there?
Sure. What came out recently in the EU High Court was a case involving eBay. eBay had been sued by L'Oreal, and L'Oreal is a Paris-based cosmetic company. And basically what L'Oreal said was they said that they didn't feel as though eBay had been doing enough to police sort of knockoff fake goods on the website. And they were able to get an order from the EU court. And basically it was just essentially the EU court saying that, perhaps the eBay would need to do more. Now, what's interesting about the case, though, is when you look at it sort of more closely, I think it's not that so much the law is that different from what we have in the U.S. with the DMCA. It's just that in that case, I think L'Oreal was able to make the requisite showing. Basically, that what the court is saying is that if you have a situation of repeat infringers and they don't feel that eBay is doing enough, then the court's going to step in and give some relief. Now, at first, I thought that this was very different, kind of a different result from the Amazon InStyler case. This is a decision that just came out about a week ago in LA Superior Court. And in that case, InStyler, which makes curling irons, was suing and saying that they wanted the court to issue an injunction against Amazon to increase the burden, essentially, to make sure that they crack down on these fake InStyler curling irons that were being listed on Amazon. But in that case, the court said that, Amazon was doing enough, that Amazon had been responsive to try to make sure that there weren't knockoff goods on its site. Amazon made a very good point in the briefings where it basically said, look, our reputation as an online marketplace really depends on us making sure that what people buy is, that they get what they think they're buying. And so in that case, the court denied the motion for a preliminary injunction. Now, I understand, though, that InStyler has already filed an appeal, a notice of appeal in that case. So, at first blush, it seemed to me that we were seeing that the European courts were applying a higher standard to these online marketplaces as far as essentially making them police more. Now, if that were the case, I would be troubled by that because, as we know, one of the burdens on someone who has a trademark is that basically they need to be policing their trademark. And I think that burden is properly with them, and that if they can make some showing to the online, internet service provider, the online marketplace, that then the online marketplace needs to, do something about it. Otherwise, they're going to lose their sort of their safe harbor protection. Now, I don't know the facts as well as in the eBay case. Apparently, the court didn't feel like they were doing enough. But at the same time, I think it's worthwhile to mention the fact that, again, L'Oreal is a Paris-based company. eBay is not. eBay, I think, is based out of the United States. And so perhaps there was a little bit of that going on there as well. So it'll be an interesting case to follow.
Yep, thanks for that update. I always am interested when businesses are being called upon to police, millions of bits of data to do the detection of infringement, and that seems to happen very, very frequently. Okay, so we have Beavis and Butthead to discuss. We may as well get to them before the show gets too much older here. Beavis and Butthead is about to come out on DVD, but if you remember these guys fondly from your childhood, you're going to find that the music included on the DVDs is not what you fondly remember, because back in the day, they did not license the music that they used for the kinds of extended markets that we see now. And when they go back and try and take that second bite of the apple, it turns out to be way too expensive. So it's just kind of sad that the Beavis and Butthead that we will experience now later on down the road isn't going to be quite the same. Fred, any thoughts here?
Well, this returns to the point we were making earlier, which is, as your 7-year-old pointed out, if you want to watch something and you're ready to pay for it and you find that there's nobody who's willing to give it to you, well, that's basically demand that's going unmet, and usually on the internet somewhere there will be a supply that will meet it. And if the authorized supplier is not willing to do it, then that often creates demand for an unauthorized supply. So I wouldn't be at all surprised if you saw a healthy market for pirated, original, probably duped from a VHS tape versions of the original Beavis and Butthead out there. That, it's the complexity of licensing the music here basically creates a lose-lose for everybody, right? The fans are unhappy because they don't get to see the originals with the original music. The MTV is unhappy because there will be a persistent demand for the originals that will be out there somewhere that will undercut their legitimate market. And then, frankly, the musicians who either you couldn't be found to license or who refused to license, they're hurt too, because to the extent fans are turning to unauthorized sources, they're foregoing revenue they otherwise could have earned if the DVDs included the original music. So I think it's a real shame that the complexity of licensing basically creates an environment where you stimulate unauthorized activity online, and you also at the same time make fans unhappy and don't get the original artists paid. So this is a great example of how licensing, the friction in that process actually is a serious problem.
It seems particularly ironic in the case of this particular creative work, if you can call Beavis and Butthead a creative work, because as I recall, and I don't recall that much of the show, pretty much it consisted of Beavis and Butthead sitting on a couch watching MTV videos and making snarky comments about them. So if you're not getting the original music, you're not really getting much of the original show. And Trevor, my apologies to you, being probably our youngest member of the panel, just taking the bar exam in New York. That do you even know who Beavis and Butthead are?
Oh, yes. When I was 12, every single person watched Beavis and Butthead.
All right, good.
That's a bad sign for your generation.
On a slightly higher plane, do you take this as a harbinger of bad things for other vintage television programming that you remember?
Well, I just find it funny, kind of going on what Fred was saying, is that the people who must be most angry about this are probably the artists, because I remember, at least back when MTV used to play music videos, back when I was a teenager, which they don't really do anymore, the best thing that could ever happen to an artist was for them to have their videos played on MTV. It gets them more exposure than they could ever dream of. And for them not to be able to have their videos played on Beavis and Butthead because the record companies are asking for too much money has to drive them almost more crazy than it would the fans.
Yep, I'd have to agree. Michelle, what do you think of this?
Well, I think Fred's point is a good one. I think the fact that as a result the show's going to suffer, I think that perhaps and hopefully we'll see the record companies recognizing that, well, it's better to have some type of licensing arrangement and maybe we won't get as much in our fees. But, you know, otherwise we've got our artists unhappy and we're not making a deal. And then we've got the general public, it's highlighting an issue with them. So I would hope that the record companies would come down in these types of situations and recognize that there's so much benefit to having sort of essentially a second life to a lot of the music that will be on the Beavis and Butthead show. And, you know, I did watch some episodes myself and it was very popular. So, I mean, really, I think the record companies perhaps are being a little short-sighted because you could essentially have a second or third demand for, you know, a song or artist that you know, had sort of retired and, you know, dust had been gathering on that person. So I think it's a missed opportunity. I hope the record companies will recognize that and think of a better way to do the licensing so it's affordable and doable.
Well, another thing people get attached to, aside from their nostalgic television they remember from their childhoods, is their creatures and virtual goods that they might purchase, be it in some sort of viral Facebook game or in Second Life, if people still play Second Life, which apparently they still do. We have a nice intro to this topic by Professor Goldman, who starts his summary of the Amaretto Ranch Breedables LLC versus Ozimals case, saying, I generally like furry critters, but I'm beginning to hate the virtual horses and virtual bunnies for their deleterious effect on internet law. Fred, how are these virtual horses and virtual bunnies throwing a wrench into things?
Well, I have to admit, I lost track of this case after the third or fourth or fifth ruling that Eric reported on his great blog. I know the most recent case, the most recent decision anyway, was this question of whether or not sending bogus takedowns, essentially, because what ends up happening is these two companies are in a fight about about their animals on Second Life, their virtual animals, being copied or stolen, and they keep sending takedown notices to one another. And basically the courts have been trying to sort that out. And the most recent decision involved the question of whether or not you could basically sue somebody for sending a bad takedown notice under state law. And the court basically said, well, no, because the DMCA has its own federal law system for DMCA notices and counter notices and a cause of action for those who send abusive misrepresentations in those notices, that basically the state law claims are set aside. But of course, the complicated thing about that is part of the case was the argument that in fact they weren't really valid DMCA notices in the first place. And so you end up with this kind of catch-22 where I'm not allowed to sue you because it's not really a DMCA notice under federal law, but then under this ruling, maybe I can't sue you under state law either because you pretended it was a DMCA notice. So, you know, the case has sort of created all kinds of these weird fights. And I think, as Professor Goldman points out, it's hard to imagine that these companies are making enough money for the expenditure on lawyers to be worth the candle. So it's a bit mysterious. And again, for those who really feel strongly about this issue in Second Life, I apologize if I am not adequately addressing your feelings about these animals. But at least from a copyright lawyer's point of view, these cases, I'm with Eric on this.
Yes, my bunny ranch is going to get all up in arms about this. Trevor, what do you think about virtual goods in general? It seems like they're in this strange space between copyright law and property law.
Yeah, well, I think there's the larger issue involved in this case is kind of the virtual currency that goes along with it. These supposedly Linden dollars, I guess they're called, where $1 US is equivalent to 250 Linden dollars apparently at this time. And people actually can make money by by trading in this kind of virtual currency. And we see this issue kind of coming up in the last few months with Bitcoin, which is essentially a kind of decentralized peer-to-peer currency, which a lot of people on the internet have been trying to promote and use. And you see that it's creating kind of havoc on the web because you have people going in, hacking and stealing people's Bitcoins. And you have such a large fluctuation in how much these Bitcoins are worth. There was a situation, Bitcoin was all the rage like 2 months ago. Everybody was talking about it. Its value was skyrocketing. And then all of a sudden, somebody stole $500,000 of Bitcoins and the largest Bitcoin market crashed, essentially, taking a Bitcoin that was worth $18 on that particular market, and then it dropped down to zero, essentially. So these virtual currencies, you know, people who don't play Second Life, I guess, or just people in general don't know that it's quite the business going on in a completely virtual world.
Right. There's a arcane legal discussion out there about the law of the horse and technology law, that, you know, you shouldn't treat things differently simply because they happen in a technological environment. The argument being you didn't need to come up with a whole new legal framework just because there were horses that had their own set of legal concerns when they got stolen and when they injured people, such that you don't need a whole new body of law to deal with technology. What do you think, Michelle? Do we need the law of the virtual horse?
You know, I absolutely agree with you. I don't think we actually need a law of the virtual horse. I was actually just looking recently at the whole idea that in conversion, for example, a claim for conversion, we define it very broadly. And for example, in California, intangible property can be converted. And, you know, in large part that kind of developed because of the idea that someone could, for example, take electronic data. It's not something physically that you can necessarily put your arms around, you know, and move from one place very easily, you know, having a physicality to it. So, you know, the fact that we are now saying that conversion, for example, or property has this very broad definition to cover things, you know, that people can, you know, create, own, sell and make money on, and we define as including intangible property. I don't see any reason why it can't include, for example, these virtual dollars, you know, currency, the virtual horse, virtual food. I think it can all fit within our sort of our definition of property. And again, you know, property is how we've defined it. I mean, it's created, it's man created, you know, person created. So I don't think we need to sort of, I guess what I'm saying is that I think it all fits within the rubric we already have. It's just a matter of sort of expanding our definition of intangible property.
Yep, I think that's probably a good take on things. I also think we haven't talked about privacy yet, or S&M, and I don't know how we can end the show without doing those things. But before we get to that, we're going to thank our second sponsor for episode 123 of This Week in Law, Squarespace.com, the fast and easy way to create a high-quality website or blog. Squarespace has easy-to-use UIs for creating and managing a website or blog. It's optimized for both beginners and CSS experts. There are hundreds of design templates to choose from, and you can customize any of the designs to fit your needs. I have my blog on squarespace.com, and it's just a joy to use and tweak. There are iPhone and iPad apps for updating your blog on the go. And really, I think it's probably the hands-down best way if you're traveling and all you want to bring with you is an iPad and you need to update things. It's really the only good blogging alternative on an iPad as far as I'm concerned. Online resources and a special support team give you personal help 24 hours a day, 7 days a week. Their all-inclusive service includes several modules to build your site. There's a blog module that includes import and export support for WordPress, Blogger, Movable Type, and TypePad. And that means you get data portability both into Squarespace and out of it. There's a form builder to collect email addresses and other information from your visitors if you need to be doing that. There's Flickr photo display where you can choose a thumbnail or slideshow view. There's a Twitter widget to display tweets on your website in a customizable and great looking format. There are social media buttons to connect your website visitors to networks on Facebook and Twitter. And I just added the +1 button from Google to my Squarespace blog, which was pretty straightforward and easy to do, especially after I did avail myself of that personal 24-hour-a-day, 7-day-a-week online help. There are Google Maps and more, website tracking so you know how many times your site is viewed, and a built-in search engine optimizer. There's permission access handling, and their cloud architecture for speed and site stability means your site is not going to go down under just about any foreseeable circumstances on the web. So use Squarespace for all your website needs. Build it, host it, and update it anytime. For a free trial, go to squarespace.com. Then you'll get 10% off for 6 months of the service when you use the offer code TWiL8, TWiL 8. Thanks so much, Squarespace, for your support of This Week in Law. So let's talk about privacy, which we haven't touched upon much in this show, other than Congress perhaps wanting to have ISPs retain data about us. We'll watch where that goes. But the Black Hat conference took place recently, and there was a presentation there about linking up one's publicly available information with facial recognition software. So you could basically, you know, it reminds me a lot of a Cory Doctorow's story where people would have these reality-enhancing goggles that, you know, you would look at someone and all of a sudden get a bunch of contextual information about them that presumably used facial recognition to link up the user with all kinds of information about who they were viewing. And so my take on this is that this kind of technology is probably inevitable, but what, if anything, do we want to do about it? Fred, does this cause you concern?
This is one where I'm going to plead. I'm just a simple country copyright lawyer. When it comes to privacy, I tend to agree with you, Denise. I think the technology is moving way quicker than our intuitions about it. And the outcome is really hard to predict. I know the Cory Doctorow story you mentioned, and I remember thinking to myself, oh gosh, I want those goggles right now because you know, I'm terrible with names, and I'm always like, oh gosh, it would be great to have an onboard assistant that would remember all that for me.
Right.
But you're
Down and Out of the Magic Kingdom for anyone who wants to read it. Great
book, highly recommended. So I think it is very hard to know exactly where this will pan out, and I'm, like I said, I'm a copyright lawyer, so I keep wondering to myself, what about the copyright in all those pictures of your face that we're going to run recognition software over?
Yes, interesting take. Trevor, what do you think about this?
Well, I just think facial recognition is probably going to be the next big privacy issue. I mean, even a couple months ago, Google's CEO, Eric Schmidt, said that Google had been experimenting with facial recognition, and they thought it was too dangerous because of the potential side effects, kind of what they were saying in Black Hat, saying that you would be able to access somebody's social security number. There was even a story I saw probably a couple weeks ago about how there's already phone app makers that are trying to run this program where, I mean, this is kind of not as serious, but it kind of tells a story about where this is going, where bars and cities will sign up for a service where they have a camera set up at the entrance of their bar, and the facial recognition software will be able to tell this company how many guys and how many girls are in the bar. And so if you download this app, it will give people an idea of how many people of each gender are in these bars. And so you can imagine the slippery slope that could create, as in where eventually you would be able to find anybody that you desire through cameras and facial recognition. So I think facial recognition is not going away, and it's definitely going to be the next big privacy fight.
Michelle, do you think there's any feasible way that people could opt out of being included in any this kind of information gathering. Here we have a posited app that once you've snapped a picture of someone could conceivably show their social security number. Other information such as sexual orientation and credit ratings could also be inferred per this article I'm looking at Network World by Timm Green. How do we deal with this kind of situation? Right. Obviously, people are going to be concerned about this.
I think that Trevor is right. This is huge on the privacy front. I think saying huge is not even emphasizing it enough. I think that this is a situation in which you shouldn't have a opt-out. It should be more of a opt-in if people even want to participate in it. I mean, this reminds me of Facebook had some type of ability where basically it would sort of suggest from your Facebook friends who might be in a picture that you've posted. And there was an incredible uproar about that. And, I know that friends of mine that are normally not that sensitive to sort of the privacy issues of data mining, they were concerned about it. And I think that this is sort of, you were mentioning Dr. Rowe, I was thinking of sort of Big Brother and Animal Farm or Orwellian stuff. It kind of raised every concern that I would have. And I think it would, I also kind of feeding into it also, another thing to think about is, as it is, we have such a problem with identity theft at the time, looking at the hacking situation, the fact that you turn on a news program on CNN and they're giving you recommendations of how you, need to change your passwords every few months. How one article I read, you shouldn't even share your password with your significant other. So I think that this is very scary stuff, and it should definitely be a situation that if they do have it, that people have to be given the option of opting in for it. Saying that, yes, they're fine with this, as opposed to having to, take that additional step and opt out.
Imagine the disclaimers this kind of an application would have to have associated with it because of the possibility for false positives and defamation and everything else that would be associated with it. It seems like the accuracy would be, if you could get 50% accuracy, I think you'd be doing really well with something like this, right, given today's technology. Okay, so sorry, go ahead.
Oh, I was just going to say, when you mentioned the false positives, it just, it reminds me of all those poor people that are on the do not fly lists. Yeah. That are not supposed to be on the do not fly list, but they happen to have the name of someone else who's on the do not fly list, and they literally cannot get themselves off. So I think I just want to kind of emphasize that point you just made. I mean, any false positive, things like that. This just has just a long list of terribles to it.
Trevor, we're talking about privacy and people who make things private and people who don't. Since you are the Twitter source for all things legal concerning WikiLeaks, you want to give us an update on that front?
Well, right now there's supposedly a grand jury investigation going on, trying to find a link between Bradley Manning, who's allegedly the original leaker of all the documents that WikiLeaks got from the U.S., and Julian Assange, essentially saying that there was a conspiracy to commit espionage. The Espionage Act, which is what they're trying to use, essentially was created during World War I and is completely not applicable today. It essentially says that anytime anybody retains classified information or communicates it to somebody else, it's a crime. Now, the big issue here is that newspapers like the New York Times, Wall Street Journal, all these newspapers publish classified information all the time. Government officials leak it without authorization. It doesn't get declassified. If you turn to the front page of a newspaper every day, you're going to see some sort of classified information. And so the problem is that if the government was to go ahead and indict Julian Assange for this supposed crime, that it could end up creating a precedent where even if the government isn't going after the New York Times right now, they just want to focus on Assange because they consider him enemy number one. Down the line in the future, it would create precedent to where if the New York Times ends up printing a story that, like take, for example, their story about illegal wiretapping. That was highly classified information. So they would have precedent to go after the New York Times and the reporters and charge them under the espionage statute for essentially informing the public and committing journalism. And so I think no matter what people's opinion is of Assange, that it could end up creating a whole host of problems for the First Amendment. And we're kind of seeing some kind of hypocrisy coming from, I had just written a piece about this from the Wall Street Journal. They've been on Wikileaks' case for a while, printing editorials saying that Assange should be charged under the Espionage Act, despite the First Amendment. And now News Corp, which owns Wall Street Journal, of course, is embroiled in this huge hacking scandal where their reporters are the ones stealing information, hacking into people's phones. And the Journal has been now printing editorials saying that that they shouldn't be charged under what is called the Foreign Corrupt Services Act, because it wasn't intended to punish publishers, and that paying people for information, which is another allegation that they were paying police, is essentially protected under the First Amendment.
Do you think with these editorials, they're somewhat ironically shooting themselves in the foot?
Yeah, I think the original articles now make it look like they're shooting themselves in the foot, because the Espionage Act, at least the section that they want to charge Assange under, specifically exempted publishers. And that's their exact argument with the Foreign Corrupt Officials Act, which is that Congress never intended to have this applicable to publishers of information. And it's just funny because, Assange was once a hacker 20 years ago, and he got his information from Bradley Manning. He didn't hack it himself. He essentially received stolen information, which is exactly what journalists are allowed to do. For the past 100 years, the courts have upheld journalists' right to actually receive information, even if they know it's stolen, and they will be protected by the First Amendment for publishing it. What the Wall Street Journal is doing is actually committing the crime themselves, essentially a step way above what WikiLeaks is even accused of. And now they're crying for protection for the First Amendment. So I just find it very ironic. And I would hope that they would reconsider their position on WikiLeaks, but that will not happen.
All right. Well, thank you for that. We have a story here. I promised you some S&M. There's been a case pending in New York by fashion photographer David LaChapelle, who has gone after singer Rihanna concerning her S&M music video. And this is a pretty interesting case that's had a pretrial ruling come about, that the photographs that David LaChapelle took had basically the same look and feel of the video. And the judge there has indicated, her name is Shira Scheindlin, that copying need not be of every detail, so long as the copy is substantially similar to the copyrighted work, so that these photographs, which are alleged to have been the inspiration, I guess, for the video, and are very similar to some of the images in the video, that it sounds like LaChapelle has scored a victory there with the judge, and may well be able to recover damages for this. Fred, is this an expansion of what we've seen in the past?
Well, this is at first a reminder to folks that this is a very early ruling in the case. The photographer had filed the lawsuit against Rihanna, and in essence, this was an early motion by her lawyers to dismiss the case. So there hasn't been any real discovery yet. There hasn't been a lot of development. And the court specifically said on the fair use issue that there wasn't enough information yet for the court to make a clear ruling. But it is interesting that it sort of points up a trend that we've seen in other fair use cases. The court really focused on the fact that the music video, in the court's eyes anyway, was not commenting or criticizing the photographs. So folks may know in copyright law, in fair use cases, we have this distinction between what are known as parodies. That's where you take an original work and comment or criticize the original in a new work, or satires, which is where you take something from a work in order to comment on something else. And for a long time, I think lawyers have sort of thought, oh, parody is okay and satire is not okay. And I don't think that's ever been the law. The law has always been parody may be favored, but satire may also sometimes be okay. And I think the judge's ruling here really kind of skips over that and essentially says that unless it's somehow commenting on the photos themselves, there's no fair use claim, or there might not be a fair use claim. I also disagree with the court when the court looks at the video and says, oh, they stole too much from the photos. When I look at the photos, I'm not sure I see the similarities quite as clearly as the court does. But of course, that really just underscores the fact that every fair use case is decided on a case-by-case basis, and reasonable people can disagree. And in fact, if this case continues forward, it might be that a jury someday disagrees with what the judge here thought in this early ruling. So for my money, the most important part of this case is this idea that you somehow have to, in order to use a work under fair use, you somehow have to comment on the work you're using. I think that is too stringent a test. In fact, there have been some recent cases, a case involving an artist named Koons, where courts have approved uses where you reuse something not to comment on the original, but to comment on something else. So I wonder if this will end up being upheld if the case moves forward. But I also think the odds are pretty good, given that this is a big-time photographer and a big-time celebrity. The odds are pretty good that this will probably settle for some undisclosed amount of money, and we may never get to reconsider the legal issues very carefully.
Yeah, those are all great observations, and I wish we could show you some side-by-sides. I'm going to put this into our Delicious links for the show at delicious.com/thisweekinlaw/123. So you can look at some side-by-side comparisons of the images that David LaChapelle took and the images from the video. And I'm with you, Fred. I mean, I think, you know, if your subject matter is S&M, it's not necessarily copying someone's photograph to show a dominatrix walking someone else in a harness like a dog. You know, that would be kind of a common theme. And some of the other images too, you know, there's a lot of latex and various things that you would anticipate given the subject matter. And, you know, I think that a jury could definitely differ on whether this was copying the look and feel of these photos or not. Trevor, what do you think of all this?
I mean, I was just actually going to make the same point you made. It seems to me that she's essentially arguing that she has copyright over an idea or a theme rather than her actual photos. She makes the claim that these are like musicians paying for samples of music. She says that musicians commonly pay for sample music or use someone's beats, and there should be no difference when sampling artists' visuals. But I think there's a difference between, or there is a stated difference between sampling somebody's work, actually taking it, or creating your own work that is substantially similar. And in this case, it seems like Rihanna is maybe copying the general style and feel of it, but she's not actually using the artist's work directly. And I think that, I mean, obviously Fred could comment on this better than I can, but I feel like the sort of music sample analogy, it doesn't hold up.
What do you think of that, Fred?
Well, I agree. I particularly agree with that because, frankly, the music sample analogy is not nearly as strong as the complaint and the briefs would suggest, right? To my knowledge, there's never been a music sampling case that has held that taking a sample is not a fair use. There are a number of cases where people were either enjoined or there was a ruling on other legal questions. But frankly, the practice of paying for music samples, is more something that's common because it's become a commonplace in the industry, not because a court has specifically addressed the question. So I think if LaChapelle wants to rely on, I'm just asking for what the guys in the sampling world get, he may be putting a little too much emphasis on an area that actually isn't as certain as that statement suggests.
Michelle, any thoughts on this? And if not, I want to get to asking you about some social media questions.
Sure. I'm just very briefly, by what I've seen, especially in following the Righthaven cases, what we're seeing is courts actually being a little more expansive with fair use, as opposed to what I think the court was doing here, at least initially, is as Fred was making the point, not really acknowledging satire. Also, I think in terms of just the substantially, strikingly similar, again, the evidence that Chappelle was offering was a lot the reaction of his own fans and thinking that it had been taken from his prior works. But I think the proper audience would be if you showed this to people that weren't necessarily a fan of Chappelle. I don't think that they are necessarily strikingly similar. You could see some of the ideas, but as some of the comments to the article suggested, you can go back in time and look at other pictures of sort of like this is a familiar sort of S&M type of imagery, and it's just she's used another variation, and I would say a creative one. So I don't see at the end of the day this being a case that LaChapelle should prevail on, but I agree with Fred, it's probably going to end up settling.
Yeah.
But on to social media, my favorite topic.
Yes. It's worth watching this photography one, I think, because of the notion of, these are certainly not identical copies. But this whole question of whether something was inspired by something else leading to liability, I think, can be a slippery slope. All right. The state of Missouri, the Show Me state, wants its teachers to be showing less online to students, and has some legislation pending that would prevent teachers from having a website that has direct contact or the capability of direct contact with students, which means that, if you're having a one-on-one interaction on Twitter or Google or social or any other social network, that could be problematic. Have you looked at this, Michelle? And what do you think about this as a precedent?
Yes, I have looked at it. And first, I think fortunately that I don't think that we're going to see many states necessarily adopting this kind of legislation. I mean, the purpose behind this legislation was a concern that there was improper sort of sexual relationships, misconduct between teachers and students. And yet, as we saw with the Wiener case, I mean, the fact that it's occurring on a social networking site, that's going to be a very public thing. So I don't think that the purpose of this legislation is going to necessarily nip in the purpose behind it is not necessarily going to be addressed by this legislation. What concerns me about this legislation is that, and we've seen this in other cases, where it's schools trying to regulate, or any type of business trying to regulate lawful conduct that's occurring on these social networking sites. And it brings to mind, for example, the teacher that a picture was taken of her. It was posted on Facebook where I think she was even on a cruise. So she was on vacation, and she had a glass of wine in one hand and a glass of beer, and she was fired by the school district. What a lot of schools actually recognize is that social networking sites is a good opportunity, for example, for their teachers to be, for example, Facebook friends with some of their students. The students are, as a result, more mindful about what they're posting on the social networking site. As we know, there's a much huger problem of cyberbullying. So I think that if it tempers the students by being Facebook friends with their teachers, that's a good thing. And so this kind of law actually concerns me, because I don't think that the social networking sites are the form in which there is this necessarily this improper communications are going on between the students and their teachers. Now I say that recognizing that There was last year an instance in New York where some teachers were actually fired because they did make improper posts on the Facebook pages of their students. But again, as I've indicated, Facebook is very public, and so it was identified. It was caught immediately. The teachers could be fired, and it was pretty outrageous what the teachers did. I mean, one of the comments, for example, was the teacher, a New York teacher, allegedly wrote on a student's picture that she had posted, "This is sexy. I'm not a gynecologist." It gets worse. "And I'm not a gynecologist, but I'll take a look inside." So, again, if there is something improper that's going on social networking sites between a teacher and a student, it's pretty much going to be very widely known. And if anything, it's going to identify the teachers that may potentially have an improper relationship with a student. And so I would think that rather than wanting to discourage that sort of public exposure, you would want to more have all the benefits that accrue from, for example, a teacher being on Twitter or on Facebook with their students. Unless something, improper happens, I just personally think that there's so many benefits to social media. For example, just even the teacher, for example, could be Facebook friends with their seminar class, and it's a great immediate way to post out some information that they should have before class. So I think this is a dangerous precedent, and I really am hoping that we won't see other states adopting or following it.
Yes, it seems like you're arguing for the give them enough rope and they'll hang themselves if they are inclined to do so.
Exactly.
Trevor, you're coming from academia, recently minted from law school. Do you have any thoughts on teachers interacting with students in this way?
Well, I just think this is just another example of using a reason to enact a law that nobody can disagree with, which in this case is to protect, teachers from sexually assaulting students, and kind of creating this expansive rule which kind of violates people's freedom of expression and freedom of association. The bill was apparently named after a student who was molested and assaulted by her high school teacher. And what would stop, if this law were to be upheld, what would stop teachers from teachers who were already inclined to molest their students if they couldn't talk to them on Facebook? It's essentially, if we had a law saying that teachers couldn't communicate with students outside of school or communicate with them on the phone, we would say, well, that's ridiculous. That's probably unconstitutional. How can you do that? So it's the same kind of analogy here. Teachers, it's the school's job to police this kind of conduct. They can obviously make a rule saying that students and teachers can't interact, and there can be punishments that way. But by the state coming in and saying that it's illegal, it's just a step too far. And at the same time, it's the school's responsibility to police their own teachers to make sure they're hiring the right people to prevent these horrible acts from occurring. Just this kind of law is just, like I said, just another example of using just a horrible criminal act to justify just a blanket restriction on people's rights.
Yeah, it seems to me, and Fred, I'm curious whether you agree, that this is ripe for some kind of First Amendment challenge, because we've got the state telling teachers that they can only express themselves in certain ways and using certain technologies, or effectively kicking them off the web and off of social media because of the breadth of this proposed law. Do you agree? Would you be surprised to see that?
Well, I think that would be an interesting issue. I just want to point out one thing about this law that I found when I was reading up on this. It's set up so that basically it only the prohibition only exists until the student turns 18. So it's not a forever, you can never friend your former students. I wonder whether or not that will influence any First Amendment challenge, the fact that it is solely trying to control the conduct, the interaction of minors. But I think this really points up a larger issue that we're all going to have to work through, not just in the field of teaching, but in lots of different professional fields where service professionals are in sensitive relationships with people. You know, this is something we're going to have to navigate. I have a good friend who's a therapist, and there's a great deal of debate in the therapy community about how and whether it is appropriate to use social media to interact with clients or former clients or potential future clients. And I think I agree with the comments that have already been made that rushing to enact laws to try to govern this stuff seems a bit premature. Lots of different professions are going to have to wrestle with this and come up with their own rules and norms, and hopefully we'll learn from all of them before we start putting them into, pouring them into law.
All right. Well, thanks for that. I want to move on to our resource and tip of the week. Our resource is Demand Progress, and Evan, who's not with us this week, sent this one in for us. Demandprogress.org. If you go to that domain and then find their urge Congress to reject the Protect IP Act page, that's at demandprogress.org/sign/PIPA_letter. The Protect IP Act that we discussed earlier on the show is in their sites, and they want to aggregate people's responses to Congresspeople and let them know that folks are concerned about the ramifications of Protect IP. So they have a way to contact your legal representatives and let them know what you think about Protect IP. They have a video there about urging Congress to reject the act, and they have some of their early results hearing back from Congresspeople. Congressman, let's see, it's actually a senator, Oregon's Jeff Merkley, told Demand Progress that Jeff has heard from many Oregonians on both sides of the issue and is going to look further into the legislation and try and address the worries that it could result in internet censorship. So if this is a big concern for you, go check out Demand Progress, and that's a nice way to interact with your representatives about this. Our tip of the week is that if you're living in the UK, rejoice, because you'll soon be able, hopefully, perhaps, to legally burn and transfer things from one digital medium to another, and that is thanks to Vince Cable, the UK Secretary of State for Business, Innovation and Skills and President of the Board of Trade. And Fred was alluding to this earlier in the show, that Mr. Cable is urging the UK to bring its copyright into line with the rest of the world, where ripping and transferring things from one device to another is just not that big a deal. But apparently it's been illegal for a long time in the UK. I was surprised to hear this, Fred. Has this always been the case?
It has always been the case. The UK has not had a private copying exception, which is quite common in the rest of Europe. And so this was one important part of a package of reforms that the UK government is urging. And so, there's a lot to pay attention to there.
That's wonderful. So if you're in the UK, get your DVD burners ready, because Vince Cable's trying to make that happen for you. All right. So I've really enjoyed this installment of This Week in Law, which we record every Friday at 11 o'clock Pacific, 1800 UTC at live.twit.tv. I hope you've enjoyed it with us as well. And between the shows, you can get in touch with me. I'm Denise at twit.tv. I post on Google Plus frequently before the show, some issues that I know are going to be fun for us to discuss. And also over on Facebook, we have a page there, facebook.com/thisweekinlaw. So if you want to give us your feedback or your thoughts about things we should discuss, I'd love to hear from you. Do get in touch via any of those ways. I'm also at Howell on Twitter. And I'd like to thank our wonderful panel, Fred von Lohmann from Google. Thanks so much for joining us, Fred.
Sure.
Fred has been using the Google Plus too, and that's probably the best way to find him and get in touch with him about anything that you may need to contact him about. but he's a busy guy over there being senior copyright counsel for Google. So we really, really appreciate you taking the time to join us today and share your insights.
Great to be here.
Also wonderful to have back on the show Trevor Timm. Trevor, what are your plans now that you've got your law degree in hand?
That's a good question. Exploring options right now, so hopefully I'll know very soon.
Good. Are you going to continue posting at the Legal As She Is Spoke blog?
Yeah, I'll probably contribute from time to time, but mainly I've been working on Twitter. My Twitter handle is WL Legal, and I post a lot about, or I was originally posting mostly just about Wikileaks and the law, but now I've kind of expanded that now that the news has slowed down to all sorts of First Amendment and freedom of information and constitutional issues. So you can check that out.
Wonderful. Thanks so much for joining us. And Michelle Sherman, it's great to virtually meet you here on the show. And thanks for doing such a great job with your social media law update blog.
Thank you so much for having me. I've enjoyed it tremendously, and I hope to be back sometime.
I'd love to have you back. Thanks, everyone. And with that, we'll adjourn court and let you go enjoy your weekend. Take care.